United States during the 1960s was curious to see what it could potentially do in order to better itself and create a new America. Numerous mind-boggling and never thought of ideas and concepts were brought about, leaving America in hope of improving its policies and conventions. In 1962, the United States was under high debate surrounding the Supreme Court case of Baker v. Carr. In this particular case, the United States Supreme Court ruled that the unfair and unequal distribution of state legislative seats was a violation of the 14th Amendment. The United States Supreme Court at the time was composed of 9 justices, all white American men. The makeup of the Supreme Court was predominantly liberal, for they believed in government action to achieve equal opportunity and equality for all. As a result of Baker v. Carr, the Supreme Court had the authority to examine cases brought by individuals that were considered to have been impaired by legislative apportionment and redistricting. More than 30 lawsuits were filed following the case. They were filed against states declaring legislative apportionment schemes as unconstitutional. The apportionment of the Alabama legislature was disputed upon by voters from Jefferson County of Birmingham, Alabama. The case would revolve around whether or not Alabama's apportionment scheme violated the 14th Amendment's Equal Protection Clause by mandating at least one representative per county and creating as many senatorial districts as there were senators, regardless of population variances. The case was first argued on November 13, 1963. The decision of the case was not decided until 7 months later, on June 15, 1964. With the case having a great deal of correlation and similarity to the Supreme Court case of Baker v. Carr, it was immediately brought to the Supreme Court, having a short path leading to the Supreme Court and no lower court rulings. The party of M.O. Sims, or the plaintiff, argued that state legislative districts must be roughly equal in population. They felt that Alabama had violated the Equal Protection Clause of the 14th Amendment because no statewide reapportionment of legislative seats had occurred since the adoption of the Alabama Constitution of 1901. They also thought that legislative districting had caused urban counties to be drastically underrepresented in state legislatures, allowing for votes from rural counties to count more than theirs. The party of R.A. Reynolds, or the defense, argued that the federal government should not interfere in what they felt made them correct, the idea that it is the state's prerogative to determine the makeup of its own legislature. By written decision of Chief Justice Earl Warren, the Supreme Court ruled that Alabama's apportionment scheme violated the Equal Protection Clause within the 14th Amendment of the United States Constitution. The court held that the Equal Protection Clause requires every state to draw its legislative districts on the basis of population equality. Chief Justice Earl Warren, in his majority opinion, stated that legislators represent people, not trees or acres. Legislators are elected by voters, not farms or cities or economic interests. If a state were to give voters in one portion of the state a much more considerable amount of weight in the vote of their legislators, the right to vote of voters in underrepresented portions of the state would be diluted. Warren declared that both houses of state legislature are to be apportioned on a population basis. Warren would add that even with the federal legislature requiring a separate apportionment for its 2 houses, there is no such need at the state level. Therefore, it is necessary that the apportionment of state legislatures expresses a one-person, one-vote policy. Associate Justice John Marshall Harlan, in his dissenting opinion, argued that states on their own should be allowed to determine the composition of their legislatures. He also denounced the Supreme Court for disregarding the initial purpose of the Equal Protection Clause, disputing that it did not extend to voting rights. The decision of Reynolds v. Sims created extensive alterations in state legislatures. Within 2 years after the case was decided, at least one house in nearly all state legislatures was held invalid. In most states, both houses were to be reapportioned. Additionally, rural supremacy diminished as urban areas obtained a vast number of legislative seats. Furthermore, the one-person, one-vote requirement would shift to the municipal level. For example, the state of South Carolina elected one state senator from each county, which resulted in the underrepresentation of urbanized areas. It constructed a reapportioned scheme and passed an amendment contributing for home rule to counties. Also, city councils and county boards adapted voting districts to reflect population. The decision of the case has allowed urban residents to participate in government on equal terms, and state governments around the country to be forced to revise their apportionment systems to resemble the one-person, one-vote principle. The case has also allowed courts to step in and enforce their own redistricting plans when they find the legislature's plan to be offensive. This decision would be interpreted as liberal constructionism due to 8 of the 9 justices having a broad definition of powers, as well as their belief that power should be held within the federal government.